Good evening. This is John Milburn for Laws 12062, Alternative Dispute Resolution. We are in the home stretch. It's week 11 and we are now, I think, 2 weeks away before the release of the take-home exam. We will talk about the take-home exam a bit tonight. Have I given you access to previous take-home exams in this subject? Perhaps I haven't.
You put one up on UCrew.
Oh, did I? Okay. Now,
Nearly gave me a heart attack.
Yeah. Well, I'm going to both comfort you and disappoint you with what I'm about to say, and that is that the nature of take-home exams that I've set in the past couple of years, and I've been doing this, I think, 4 years now, this subject, is going to be different to what you can expect this year. So this year, you will have less contact with the outside world in terms of what I expect you to do in answering the take-home exam. So it will be more theoretically rather than practically based. For those of you that may have had access to the previous exam or examination that I put up on UCrew, the exam was more practical in the sense that I wanted you to actually engage with courts and ADR practitioners. So I don't have that expectation of you on this occasion. It will be a matter of answering from your own research, notes, and of course, in a second year subject in law, I expect you to go well beyond the textbook. I do expect you to set out your material in a professional manner. Again, those of you who've worked with me, you know what I'm like. I want it to look the part. I'm expecting that you're presenting something at the level of a first-year lawyer. You might be charging $250, $300 per hour. I want it to look as though you can justify that fee. You do need to reference your material in accordance with the Australian Guide to Legal Citations, and you need to reference accurately and completely. The disadvantage of having a take-home exam as opposed to an invigilated handwritten exam is that you've got to do things to a better standard. That includes the referencing and the layout. I won't go any more than that. If you need some special help, if you really don't have a grasp of what you think it is that I expect, then please ask a question through UCrew, or if you're really stuck, send me an email, but I'd rather you ask a question in UCrew. And if you have any doubts, please don't be afraid to ask. I'd rather we deal with that rather than me be disappointed when I see your paper. Okay? So you can ask now any specific questions, or you can think about it and ask some questions on UCrew. As a guide, I think I uploaded what I call a sample document, just to give you an idea of a sample of a layout and the manner of referencing that I would expect. That said, the way I've laid out my document is vastly inferior to what I've seen from other students who really present things in a very inventive and professional manner. Okay, so that's the layout of the exam and what we're leading to, and a general comments about the exam. This week, the topic specifically for discussion is the future of ADR, and the issue is also about special issues in practice. So tonight will be specific and will be general. I'll deal with the more general part first, and the general part is based around the comments in your text at chapter 10. This is important for the examination, but it's even more important for those of you that wish to practice in ADR. So I'd urge you to read chapter 10 and read it carefully. And I'm going to draw your attention to a few important points in chapter 10 that I think are worthy of specific comment. The first is this. Spencer makes the point quite rightly that there has been a rise in legislative court annexed programs in relation to ADR. Well, we know that, and we'll go through a few examples tonight more specifically. But in general terms, in many pieces of legislation now, you will see reference to case management, compulsory forms of ADR. That might be mediation, it might be experts' conclaves, it might be some other form of conciliation perhaps. And in addition to the mechanics which are laid out in pieces of legislation, we see more often than not overriding objectives. And those overriding objectives are all to do with case management and the efficient administration of justice. And you'll see words like, and Spencer identifies it, the overriding objective in civil proceedings is that courts, lawyers and clients must facilitate the just, quick and cheap resolution of the real issues in the proceedings. So what we're seeing there is a change in emphasis from the adversarial approach to a more moderate approach which relies more heavily on ADR. So a question that you might need to consider for practice and also perhaps for the exam is in relation to how you could do something that will assist in facilitating the just, quick and cheap resolution of the real issues in proceedings. So I want you to be aware of that phrase and look for it in particular pieces of legislation. Okay, now in terms of practice in ADR, Spencer goes on, and this is at page 316, to say a full service dispute resolution practitioner or conflict coach or advisor is nowadays better placed to assist disputants with an array of options available as compared to just a conciliator or mediator. A person who can assist a client in avoiding disputes is probably of more value than a person who can help resolve the dispute once it has formally arisen. A combination of both is worth even more in the marketplace. Please think carefully about those comments if you wish to practice in ADR. To be honest, and Spencer makes this point, whereas some of us who practiced mediation and studied mediation in the late 80s, early 90s were relatively rare in number, there really has been an explosion in the number of mediators and conciliators. So I don't wish to dissuade you from becoming a mediator or conciliator, but what I want you to do is think about how you can become a full service dispute resolution advisor or practitioner, to mirror the words of Spencer. So think about how you could actually practice as a conflict coach or advisor or some other form of ADR practitioner to supplement rather than supplement mediation and conciliation, rather than simply rely upon those things. And the question that you may have may be theoretical in the sense that I may ask you to consider a number of ADR options in determining how you might deal with a particular problem. Maybe even how you might deal with a particular problem before it's arisen, a time machine problem. Do you understand what I mean? So the emphasis on preventative ADR practice is something that is likely to grow in the future. So how can you be a person who can assist a client to avoid disputes? Because Spencer says that person, that ADR practitioner, is probably more valuable than the ADR practitioner who can help resolve the dispute once it's arisen. So think about those words, both for the exam and for your future practice. One thing that's odd, I guess, about ADR within the law school is this. Let me explain it in a way that hopefully makes sense. When I went through law school in the 70s and very early 80s, it was all about advocacy and adversarial litigation. It was all against you versus him or you versus her. Do you understand what I mean? In the 80s, the 90s, ADR started to bring on. So now we have a situation where in the law school we have subjects like this embodied which talk about ADR practice, as opposed to essentially most of the other subjects in the law school which talk about adversarial practice. Now that is changing. Civil practice and other practice, other subjects now talk about ADR as part of the practice. So it is changing. But ADR is fundamentally different in its emphasis to other parts of the law degree. But it's a really important part in terms of the future for practitioners in law. Have a look at the commentary on pages 317 through to 321 in your text. And I want to bring these things to your attention. Figure 10.1 is really fascinating, and it shows the list of civil cases disposed of in the Sydney Registry of the District Court, New South Wales, by trial and settlement from 1990 through to 2009. See, 1990 is significant because that's when we started to see the onset of ADR practice in a widespread manner. Figure 10, says Spencer, shows the New South Wales District Court disposal rate and the manner in which cases are disposed of. Again, there are peaks and troughs, but you will see a dramatic decrease in the number of cases. You'll see a dramatic decrease in the number of cases that are determined by trial, and you'll see an increase generally, or you'll see a decrease in settlement as well. But on 318, Spencer explains that and says, the court's data shows that trials in the court are diminishing. Now that may in part, and I think a substantial part, be due to a decrease in filings, very substantial part. Filings have decreased in that district court from a high of 18,500 in 1990 to 3,600 in 2009. That's a huge volume of work that is no longer going through the court system. You might ask yourself, in the context of an exam question or practice, why is that happening? Are people becoming less Are there less disputes? I don't think so. I think there's probably more disputes. There's more people. I don't think the level of dispute, the ratio of people to disputes has gone down, but certainly the number of people that are filing in court is dropping dramatically. So why is that happening? If you're reflecting on ADR practice, you might think about that in the context of what sort of law you want to practice in and where and how you can fit in. Why is it happening? Spencer offers a few suggestions, better case management techniques that are enforced by the courts through legislation, subordinate legislation, and court practice direction. So, if you had a problem in your take-home exam that raised a dispute, let's say in the federal court, and I wanted you to talk about the case management techniques enforced by that court, you'll need to know them. Also, the rise of court-annexed statutory dispute resolution schemes, the creation of tribunals, the inclusion of dispute resolution in most courses for university, and the cost of litigation are some of the factors. So think about all of that in terms of the work that you do. I mean, for example, in the 90s, I didn't do any tribunal work at all, but now quite a lot of my practice is tribunal work. So these things are important in terms of what you want to do. And on page 320, there's a quote about Chief Justice Doyle from the Supreme Court of South Australia, who says that by the end of the century, judges will be running cases in a more directive fashion in virtual courtrooms. Well, we're seeing a lot of that already. We are now starting to see much more case management, and we're starting to see e-courts become more and more popular. Okay, that's all I'm going to talk about in terms of general future for ADR practice, but I hope that that's of some relevance to you in terms of your future aspirations. Now, are there any questions?
John, can you hear
Yes.
me? Yeah, oh good, because my microphone's been playing up. In terms of the exam, like, what's a good way to sort of gauge, not necessarily topics that may come up, but just in terms of the questions that you're going to ask and how they sit out and how you want them answered? Is answering the weekly tutorial problems like a good gauge of what's going to come up, or yeah?
Yes, I would say that's a very good gauge. I haven't discussed many of the weekly tutorial problems because we just haven't had that many answers. But yeah, I would have a look at the weekly problems. I think that's a good gauge. Good question. Anything else? All right. So let's talk now about some of the specialised processes in the court system within the context of ADR. I think I've talked about QCAT, Queensland Civil and Administrative Tribunal, Practice Direction number 1 of 2012. for QCAT deals with hybrid hearings. Also in QCAT, we have expert conclaves. Have a look at Practice Direction number 4 of 2009, which is a guide to the use of expert conclaves. Think about the way in which technology is now increasing, and think about how that might be an opportunity for you as well. All right, now the next specific thing that I want to talk about is ADR and criminal law procedures. A good website is on the Queensland government website. I'm going to share the screen to show you this, and hopefully this is the screen. So you should be able to see a website, Justice Mediation. Is that right? Can you just give me a nod? Yeah, thank you, Tamara. Thank you, Paul. So, Justice Mediation. Has anyone looked at this topic yet? No, not getting any. All right. So do have a look at this. It's important. In criminal law, justice mediation provides an opportunity for parties to meet in a manner that is different to the usual practice for the conduct of litigation. And in justice mediation, sorry, I'm just going to just pause for a sec because I want to find something. So if you can bear with me a moment. No, okay. All right, so justice mediation is something that can be used in a number of different scenarios, and it is something that you should consider if you are advising a client in relation to matters where the client has been charged with a range of offences, and the idea is that the parties have an opportunity to confer with each other and discuss issues that will resolve the matter short of a trial, or indeed will allow the parties to deal with the matter before the charges are laid. Sometimes the mediation can occur after the charges are laid. So justice mediation is all about restorative justice, if you can recall our discussions on that. And the idea is to help repair relationships, but also provide better justice to the victims and perhaps the community at large. So it's been around for a little while, but it's now formally administered through the justice mediation section. Not throughout the state. We have justice mediation available through Brisbane, various suburbs, and some regional areas, but not all regional areas. So in my area, we don't have the justice mediation program operable. So from time to time, people ask me to act as the justice mediator in a private capacity. Now, when it comes to the authority to undertake justice mediation, have a look at the Justices Act, and I'll drag that down so hopefully we can see it. My computer's just not playing ball exactly at the moment, but you should now be able to see an extract from Ostley, and I'd like you to have a look at this division here, dealing with summonses, and 53A provides power to order mediation. So this is under the Justices Act, which deals with the issues in the Magistrates Court. So a magistrate may require a person, may order the complainant to submit the matter to mediation under the Dispute Resolution Act, and the magistrate or the clerk may make the order if they consider that the matter would be better resolved by mediation rather than proceedings on summons. So who do you think is likely to submit that that's an appropriate course of action in relation to a criminal law matter.
Could the police submit that?
Yeah, maybe. The police might. In my experience, though, it tends to be defence-driven, in that defence are looking for a way to deal with charges, potentially serious charges. So relying upon that section, they make a request for an order in relation to mediation. Also, in that section, we should look at, in that Act, have a look at section 88, which provides for adjournment of the hearing, and 88 1B. I'm told that we're going to get very fast internet here where I practice in Hervey Bay. We're getting fast internet at one stage. I can't wait. All right, so you can see there that in relation to an offence, there's an opportunity to adjourn the proceedings so that the matter can be determined by justices or in the case, justice. The power to adjourn relates also, here it is, 1B, relates to charges which are referred to mediation under the Dispute Resolution Act. So keep those things in mind and do have a look at the website to get an idea of how you might use that justice mediation program in practice. In reality, it's pretty widespread and it can be used for all sorts of complaints. And I'm just looking to see where it's on the website, but basically assault matters, fraud, stealing type matters are amongst willful damage is another good one where, there we are, some notes there about the type of matters that can be dealt with in relation to mediation, justice mediation. Obviously, your job, if you're acting on defence, is to try and get the best outcome you can for your client, and this is often a good way of doing it. There are limitations, of course. It wouldn't necessarily be a good way of dealing with a domestic violence issue. There is another technique that I want to show you when it comes to domestic violence or stalking type things, but it can certainly be very useful where the parties have had a relationship, and in a way, given that it's a restorative justice, it may provide the parties with an opportunity to re-establish a relationship. Look, if the mediation doesn't work, then it goes back to the referrer, which is perhaps the police, to follow through with the original matter. But the idea from a defence perspective is that the charges essentially go away. All right, so that's justice mediation. Have a look at the website, have a quick look at the legislation, and try to figure out how you would use that in practice. I mentioned that there are other procedures that might be available to you in terms of criminal law. I'm just going to show you some of those now. I mentioned stalking as perhaps not being an appropriate way to deal with, justice mediation not being necessarily an appropriate way to deal with it for stalking type charges. So if you can bear with me, I'll see if I can find what it is that I wish to show you. So a technique that I think is pretty common, I've certainly used it, it's pretty common, if you're acting for a party charged with stalking, is to see if you can resolve the matter by reference to section 359 cap F of the Criminal Code. It's essentially a restraining order. And this order, this restraining order, is something that the court can make essentially in lieu of another penalty that might otherwise be imposed. The restraining order carries with it an obligation to comply, and failure to comply with the restraining order, if made, is in itself a criminal charge. So if you're acting for defence and you wish to promote a restraining order, be aware that your client will dig him or herself into a deeper hole if he or she breaches the order. but it's a very effective way of dealing with particularly stalking charges. So keep that one in mind. Other diversions that might be available through the criminal law procedures relate to, for example, drugs. And we have the court diversion program, which means that rather than have a person suffer a conviction involving perhaps a fine or other penalty or a recorded conviction, in certain circumstances, if a person is charged with minor, if I can use that term, drug-related offences, then upon application, the court may divert that client to court diversion or drug diversion, as we often call it, and that's the way to do it, by using one of those forms. We have similar processes for children, and that's a youth justice youth justice conference. So I won't go into any more detail on that just yet. Now, was I sharing the screen then? I don't think I was sharing the screen, was I? No. Okay, I'll just share the screen now. Sorry, I'm pretending as if I'm showing you documents and I'm not even sharing the screen. So there is the court diversion program eligibility assessment. And I'm sorry I've deleted the stalking undertaking as well. Not sure I can get it back because I think I've neglected to show you that one. But I will post it on uCrew, and it may even be on Moodle already. Okay. So any questions about the criminal law process, how you can use ADR in criminal law conferencing? I should just say that there is another procedure. It's called case conferencing. Case conferencing, I guess, used to be known as plea bargaining. That's how it's known in the United States. In a way, it's always been in Australia. It's always been in Queensland. But in 2010, the process was formalised as a result of the Moynihan reforms. And case conferencing works at a magistrate's court level where formal offers are made to resolve matters in a certain manner. And there are certain prescribed procedures that go through the court process. So the court is aware of these procedures now, and it's a way of resolving issues without necessarily going to trial. I mentioned children, the Youth Justice Conference program. Do have a look at that. All right, so that's a brief overview. Stalking, as I mentioned, 359 Cap F, and there is the prescribed form, which I will provide to you. Justice mediation, I think I've covered everything. I'm just looking at some notes that I've put up on my screen for myself. So justice mediation, a meeting between a person who's been harmed and the person responsible for the procedure. It is voluntary, confidential. It's a diversionary program. It's only for the adults, and it's based on restorative justice. And it works very well where people have lapsed through alcohol, or there may be an issue involving family members, for example. And obviously, it's part of a good defence strategy, I think. So there are issues for you to consider. Okay, any questions about criminal law? Because that's all we're going to deal with. All good? Okay. Let's move on to some other issues. I have mentioned, I think, the land court. Have a look at the land court practice directions. I think I wrote a paper on this, which I probably uploaded somewhere on Moodle. So the President of the Court issued some practice directions, number 1 and number 2 of 2015, which provide for alternative dispute resolution procedures in relation to the valuation of land, and that's under the Land Valuation Act. It provides a method for preliminary conferences, and it's a way of encouraging settlements in the local area where the dispute arose. The current president of the Land Court is Judge Kingham. She is a great advocate of ADR. She established, Her Honour established many of the practices in the Planning and Environment Court when I think, Peter Stilgo, member of the Land Court, was also instrumental in those processes. She's now a member of the Land Court. She was, I believe, a registrar of the Her Honour was a registrar of the Planning and Environment Court. So the Land Court and the Planning and Environment Court are working in many ways in a similar space in terms of promoting ADR practice. And I believe I may have a practice direction, which I'll see if I can call up on the screen and share with you, if I've got it. You just bear with me a moment. No, I can't see it. Sorry. I was sure I had it and it's gone missing. Just bear with me one sec. To apologise. No, I can't see it. All right, so have a look at practice direction number 2 of 2014 for the Planning and Environment Court. In fact, what I might do is I'll see if I can find it now, because it is important, and what it shows is the future in many ways of practice in this area. Ah, here it is. I do have it after all. I'll share the screen. Okay, practice direction number 2 of 2014. This is a really good way to get a feel for how ADR practice works in a court context. So the purpose of the practice direction is to set out the case management procedures. You can see that I'm having trouble here. My internet connection is unstable. For the just and expeditious resolution of the real issues and proceedings and a minimum of expense. So that's the sort of terminology that I was talking about at the start of tonight's session. And you'll see that increasingly in legislation, practice directions, and these are all opportunities for you to assist your client in resolving a dispute, but there are also opportunities for you to do work in this area of practice. So I would urge you to have a look at that practice direction, perhaps get a feel for it, even print it out, because it'll give you a very good idea of the way in which these things work in practice. Okay, I'll stop the share there. Perhaps the only other thing that I want to talk about is becoming a family dispute resolution practitioner. And I think it's worth having a look at what's involved in becoming a nationally accredited mediator and what's involved in becoming a family dispute resolution practitioner. The process is not cheap, but if you wish to work in that field, may be very worthwhile considering. So to become a family dispute resolution practitioner, you need to consider the Family Dispute Resolution Practitioners Regulations, the family law regulations which relate to family dispute resolution practitioners. Have a look at those regulations from 2008. There is specific criteria about what you need to have completed in order to become an FDRP, and there are prerequisites for seeking a placement in a course that provides you the opportunity to do that. Once you do become a family dispute resolution practitioner, you have an opportunity to deal with issues to do with children and provide the certificate 6DI certificates that are a prerequisite for litigation. Okay, that's about it for tonight. That's almost about it for the course, actually, because next week I propose to do a review, answer any questions of a specific or general nature about the exam. This week we'll try to provide you with some hints as to what's on the exam. I've provided a few tonight. Are there any questions before we wrap it up?
John?
Yes, Karen?
In this week's readings, you referred to the David Hoffman Mediation and the Art of Shuttle Diplomacy. I have not been able to locate that article anywhere.
Yeah, likewise.
Sorry, Karen. Thank you. And Paul, you had the same problem. So that's the matter of Hoffman. Okay. I'll chase that up. It surprised me that that's the second one this year. So they were there previously when I checked, but they seem to have disappeared. Okay, I'll check that out. Thank you. Any other questions, comments?
Yeah,
Yes,
John.
Paul?
I think I'm just trying to think what I was reading. I was reading in Spencer, and it was talking about mediation where you have self-representation on one side and a lawyer on the other. And I was just wondering, in that situation, I mean, there's a potential for like an imbalance. So, can the mediator sort of, ask the solicitor to either to withdraw, withdraw to just to be spoken to by his client at periods during the mediation, instead of sort of him sitting there, with his client and the other person, which would give the impression of an imbalance, if nothing else.
No, it's a very, very good question. Good scenario. What does everyone think? Does anyone wish to provide an opinion or a response, an answer?
Well, I would have thought that, like, if you've got a self-represented person, but then you've also got a client there that's got a lawyer with them, like, what's the reasoning behind them having legal representation with them? Because all through we've been learning that it's, say, for example, like just the mediator, person A and person B, without anybody else. So I'm just sort of wondering whether, whether it could be explored as to why that client feels they need the legal representation there, and then sort of go from there as to whether, like Paul said, whether you can tell the lawyer to, sort of remove themselves.
Thank you, Tamara. Any other thoughts, comments? Yes, Paul? No?
No.
All right. Well, look, perhaps I've misled you in this sense, and I'm glad you raised that, Paul, and thank you for your response, Tamara. In a mediation session or conciliation, it's actually very common to have lawyers representing the parties. So even though I've been talking about the relationship between the mediator or conciliator with the parties, which was really what you did in your first session, in practice, it's very common to have lawyers. Usually on both sides, but not always. And if there is a lawyer...
Sorry, do you mean as in like the lawyer and the client are sitting there together? Right, okay.
Exactly, as a team. So look, I've glossed over that, so that's me not explaining how it is in practice. So yes, the lawyer, the client or clients, there might be 2 or 3 from a company, for example, will be on one side of the table, the mediator or conciliator in the middle, and the other side. Now, the other side may just be a single person without a lawyer. If that's the case, the mediator or conciliator has a special obligation to ensure that the power imbalance is dealt with appropriately. And sometimes that means providing an explanation. It might mean encouraging the party who is not represented to have a break, to seek advice in relation to a certain aspect, or to consider their position by having an adjournment of the mediation or conciliation for that purpose. But there is no rule that says that simply because a party has a lawyer that there is necessarily going to be an unfair mediation. There are ways that the mediator or conciliator can control that process. In some jurisdictions, it provides that the default position is that the parties themselves will attend the mediation or conciliation, and they must seek leave to have their lawyer attend. So that reverses the situation, but the usual default position is that if you are at a mediation, then you're perfectly entitled to bring your lawyer with you. So as ADR practitioners, or knowing about ADR practice, it provides you with a good marketing ability to say, well, I know better, I know what's involved in these mediations and conciliation, so you can represent parties even if you're not the mediator or conciliator for the matter. Thank you, Paul. I hope that answers your question, Tamara. Thank you for your comments.
Thank you.
Right, any other questions, comments? All good? All right. Okay, we'll try to give you some hints during the week. It won't be many, but do your study guides and the weekly problems is a good idea. Okay, all the best. See you then.